Welcome to the Canadian Intellectual Property Office, CIPO's, educational video series called IP Protection Abroad, Leveraging IP in New Markets. Part 1. Common Mistakes. In this video, you'll learn about some of the common intellectual property or IP mistakes that can seriously impact a business when its operations, products or services are going abroad.
Canadian companies are increasingly turning their attention to markets outside Canada. So, if you're thinking of doing business abroad, what do you need to consider?
Well, if you're planning to sell an existing product in a new market, you'll probably start by thinking about the market potential of your target market abroad. If you've been successful in marketing a certain product or service in the domestic market, there's a good chance that you'll also be successful in other regions where similar consumer and market realities exist. But you need to verify if market conditions and potential demands are similar. You'll also need to perform a competitive analysis and determine the potential local price of your product or service in that specific market. You'll need to know if your product and business are subject to any regulations, and if at some point you'll need to rely on local partners for a range of critical business functions such as manufacturing, assembly, packaging, distribution, sales, marketing, advertising, and after-sales services. However, what is often overlooked is IP. Planning for IP too late could be detrimental to a business.
IP considerations are often left until later, as businesses evolve. This may be because many mistakenly believe that IP rights are global and that a patent, trademark, or industrial design registration in one country gives them IP protection worldwide. But IP rights are territorial. This means, for example, a Canadian patent, trademark, or industrial design only provides you with an exclusive right in Canada, not abroad. It's also easy to forget about IP when you're starting your business if you only have the Canadian market in mind. So it may seem unnecessary to seek IP protection in other countries for a product you only intend to sell in Canada. But as you'll see in the next few minutes, protecting your IP abroad in a timely manner can be critical, especially if you intend to engage with clients, manufacturers, or suppliers abroad.
Meet Bianca, our fictitious inventor and designer. Bianca has designed a sturdy boot built to last through Canadian cold winters. It has special soles to prevent slipping, a high-quality lining for warmth, and a few design details so that consumers can quickly identify Bianca's boots in the store. When Bianca created these boots, she was convinced they'd have potential in the Canadian market. She submitted and obtained industrial design registrations for the various aspects of the boot's unique visual appearance and registered a trademark for the brand. Once the boots were available in the store, the success was almost instant and Bianca was very happy. Quite soon, some of the competing brands started to produce sturdy winter boots but at a lower price. To stay competitive, Bianca decided to investigate if she could source some of the materials from the boots from elsewhere. Wearing her boots, she traveled to a range of countries to talk to material suppliers and manufacturers and found a few businesses willing to help. Once again, Bianca was successful. She found suppliers abroad to help her reduce the price of the boots so that she could keep and even grow her market share. Things are going well. Soon, Bianca will celebrate the first shipment to the United States. This is a big step into a much bigger market. As the winter is coming to an end, Bianca is investigating if she could expand into Europe, where sturdy boots are also popular. But as she looks online for boots in Europe, she discovers that several stores in Europe are selling very similar boots. They look like her boots. She reaches for the phone to call the stores in Europe, but before she can dial the number, someone from the US calls to notify her that the shipment to the US has been detained by US Customs and that it's infringing on someone else's IP rights in the US. How is all this possible?
Well, although this is a fictitious story, poor planning and misunderstanding or lack of awareness of IP rights can get you into serious trouble. This is why it's important to learn about the differences between the IP systems of different countries and the time-sensitive nature of intellectual property rights.
Bianca didn't do sufficient research for IP abroad to see if similar boots already had IP protection. This may become a serious barrier for her to enter both the US and the European markets. She may be infringing on existing IP rights in the US, but we don't know if there's a similar trademark to Bianca's in Europe. If there isn't, Bianca may be able to register her trademark in another country, even though her trademark has been registered in Canada. But Bianca made the mistake of not planning ahead for protecting the industrial designs abroad. Now, her Canadian industrial designs could also prevent her from protecting them elsewhere, since they're no longer considered novel, a common requirement for designs and patents around the world. Plan ahead for your IP abroad. So, what do we mean by abroad?
Well, it can be much more than just your target market. These days, most products and services have a foreign component, so IP protection is a global concern. You need to consider protecting your IP in the jurisdictions where you plan to discuss, display, sell, or manufacture your product. And that's not all. As we saw in Bianca's example, someone else, an unknown manufacturer, is already making a very similar version of Bianca's product. If Bianca had filed for and obtained exclusive IP rights for her boots abroad, she would have known about this, and that if she'd obtained IP rights, she could also prevent others from copying, manufacturing, or importing the products. A formal IP right can be critical to preventing knockoffs or counterfeit products from moving through customs.
So, by now we've learned that IP rights are territorial. To give you an idea of where others file for IP rights, we'll now look at the top destinations for Canadian IP filings in other countries.
This graph shows the top destinations for patent, trademark, and industrial design filings made by Canadians in 2017. Starting from the left, we can see that Canadians filed more than 13,300 patents in the US in 2017. The second most common destination is the European Patent Office, or EPO, which includes most European countries. Finally, Canadians also filed for patent rights in China. Together, these three destinations accounted for 81% of patent applications filed abroad by Canadians. Similarly, as the middle group of bars indicates, the United States, China, and the European Union, or EU, are the top destinations for trademark registrations. Of these destinations, the Canadian filings in China are increasing the most. Industrial designs are an area that some experts think is underutilized. The set of bars on the right indicates that compared to patents and trademarks, the number of foreign filings for industrial designs is quite low. The US received 960 filings from Canadians, accounting for 2/3 of filings abroad. The EU and China represent 11% and 8% of the total share, respectively. These two destinations accounted for 86% of total industrial design filings abroad by Canadians, a share that has remained relatively unchanged since 2007.
Based on statistics from the World Intellectual Property Organization, or WIPO, we know that in 2017 and 2018, regardless of the origin of the applicant, more than 10% of patent filings in the US were related to computer technologies, followed by digital communications and medical technologies.
This is similar to China, where computer technologies are also the most common technology for patent filings. Other common technologies for patents in China include electrical machinery, measurement, special machines, and machine tools.
Finally, the European Patent Office, EPO, commonly receives patent applications related to medical technologies, digital communication, computer technologies, electrical machinery, and transport.
For trademarks, WIPO data shows that in both the EU and the US, a large portion of trademark applications were for product brands in industries relating to product and service class 9. This includes scientific, photographic, and measurement instruments, recording equipment, and computers and software. For these regions, the second most common trademark is Class 35, which relates to services for business such as advertising, business management, and business administration. For the trademark applications in China in 2017 and 2018, this was also the most frequently used class. The second most frequently used class related to products like clothing, footwear, and headwear.
So, what's interesting or good to know about these numbers, and why do we talk about them in the context of common mistakes? Well, remember the story about Bianca's boots? If Bianca had researched IP and trademarks for boots, she would have found that the vast majority of trademark applications related to products for clothing, footwear, and headgear are registered in China. In 2017, the US was the second most popular destination for trademark registration in this product category. So, if Bianca had known about the use of trademarks in China and the US, she may have understood the need to research how to register a trademark there. In fact, had she researched industrial designs, Bianca would have found WIPO data indicating that clothing is the second most common class of industrial designs after furnishing. Clothing designs are most often protected in European countries, the Republic of Korea, the United Kingdom, and India.
Yes, Bianca's case illustrates the need to plan ahead for IP in order to leverage your IP assets abroad. IP data is available for free, and as we'll explore in the other videos in the series of IP rights abroad, expertise is available to help Canadian businesses learn more about IP in their target countries to minimize the risk of getting into trouble later.
By now we know that IP rights are territorial and that Bianca should have considered IP protection abroad much earlier. Another common mistake is to reveal or to disclose too much information too soon. Tell us about the potential risks of disclosure and why you need to minimize it before you seek formal protection.
Well, before any formal IP protection is arranged, someone like Bianca should plan what information they need to share and what information to keep secret. Before you file applications for IP rights, it is a good idea to keep the information sharing to a minimum, and, where possible, under confidentiality agreements. Creators of designs and inventions should be very careful with disclosures before they've developed and implemented a plan for their IP abroad. Failure to do so may allow someone to copy the idea in a foreign market or bring it to another country. So, don't disclose your invention too early. You may be tempted to show it off at a conference or a trade show, but there's a risk to doing so. Someone may steal your idea.
Yes, and not only that. The information you provide may also be considered a public disclosure. This may prevent you from getting a patent or an industrial design registration. Nearly all countries have a first-to-file patent system as opposed to first-invent system. So even if you can prove that you were the first to think of the invention, you'll lose the race if a competing inventor files before you do.
Yes, another important aspect of filing for IP rights abroad, and a common mistake that many make, is thinking that IP laws, rules, and regulations are the same everywhere. Let's think about some of the main differences you may encounter as you seek IP rights abroad.
Yes, think about public disclosure again. Some jurisdictions have something called a grace period, applicable to patent and industrial designs. This is a period that some countries allow between the time an invention or a design is disclosed publicly, for example, in a scientific publication or a seminar or conference, and the time the application for IP rights is filed. Patents and industrial designs require novelty as a criteria for patentability or registrability. A disclosure before the application is filed may actually destroy the novelty of the invention or design, even if it's the inventor who makes the disclosure. But if this grace period is allowed, there may be differences from country to country in how long it lasts and what is considered a disclosure, or what is authorized or not. So, it's often best not to disclose anything without first having consulted an IP professional and having confidentiality or non-disclosure agreements in place.
Oh, and it's also important to verify who can file your IP rights and represent you in front of an IP office. In some jurisdictions, unless you have a registered business entity in that jurisdiction, only an authorized professional, such as a local lawyer or an IP agent, can represent you and manage your filings. As we'll also discuss in the fourth video about applying for IP rights abroad, regulations can also vary when it comes to what's eligible for IP protection, such as biological matter and software.
And although a lot of work has been done to harmonize the various classes of inventions and trademarks, these may still vary depending on where you're seeking protection. Some countries, like China, have more detailed classes for products and services. So it's a good idea to learn about these beforehand to make sure you register the trademark in the correct class or classes.
Yes, so if Bianca, for instance, wanted to also sell branded socks, she'd need to register her trademark in two classes, one for the boots and another for the socks, since these are different subclasses of the Chinese trademark system.
Yes, and some countries don't have any so called use requirements to file for trademarks, making it easier for so called trademark squatters to register known trademarks so that they can sell or license the rights to someone who needs them later on. And other countries, including Canada, have common law jurisdictions, which means that someone may have common law trademark rights they can enforce without first having to register with the IP office.
Now you know about some of the common mistakes and their consequences that businesses should try to avoid. Watch the entire video series to learn about ways to avoid these mistakes. Exporting to an international market can be an exciting way to expand your business. Some of Canada's most successful exporters can testify that the demand is out there. To leverage your IP assets, plan ahead for your IP abroad. Research your destination and the risks and opportunities, and decide where you want your IP to be protected. Learn about the local rules and the ways of doing things. Make sure your destination can accommodate for the IP rights you need, and don't leave critical information exposed.
To make sure you protect your IP before you apply for formal protection, make sure to watch the next video, where you will learn about ways to minimize the disclosure of business critical information.